care of and get to know each other a little bit before we addressed this matter. And so Mr. Patterson did just that. He waited that length of time and came back to the leadership to ask again that this be considered by council. So the leadership did put that on the agenda for a work session, which was held the 24th of April. And we discussed it. And at that time, based on the information that we had in front of us, there was broad agreement that this was an appropriate thing to do, so that an employee who is carrying out duties as assigned wouldn't ever have to worry about paying punitive damages if they were sued for doing their job. And so we had that discussion, and it was placed on the consent agenda because it also, at that time anyway, was not a controversial matter in the eyes of council. So that has changed, and there is some controversy about this, and so that is why we're discussing it this evening. So I thought people should know that before we go any further.
Sure. And let me sort of go from that and say what, in effect, this amendment that's before council does is codify what already exists in the law. And I say that simply because if a public employee is acting, or a manager or a policymaker is acting in the course and scope of their employment, under Wyoming law, this municipality would be liable for punitive damages. And so this really just puts it in writing. And the reason that becomes necessary is because insurance companies, as well as the Wyoming Association of Risk Management, WARM, have on occasion written up their policies or their coverage to exclude punitive damages. And so for a contract employee, they're sort of in a gray area where they say, well, are we covered, when I have a letter saying there's no coverage? Under the law, there really is coverage, but that's not coverage, that's misnomer, but that the city would be responsible to pay those damages if they're acting in the course and scope. Of their employment. So that's the critical distinction that we have here. So again, this is not sort of a giveaway in the sense of that there's always punitive damages assessed. As I explained earlier, this is a rare event. I found one Wyoming reported case back in 1977 where there was a determination that the police officers were assessed punitive damages for their conduct in making an arrest. Since that time, the Wyoming Government Claims Act has been amended to where there can be no assessment against a municipality or its public employees. So that's written into the law under state law. And so there can be no punitive damages for state law claims. That leaves us federal law claims. And under federal law, the U.S. Supreme Court has determined that cities cannot be liable because they are immune under common law. So where that leaves certain contract employees is that they really act as the municipality when they act as a policymaker. And so they're really stepping into the shoes of the municipality. So what's developed is this weird exception where if you sue a policymaker as an individual, then you have an opportunity to perhaps to get punitive damages. I'm not aware, as I said, of any reported case where a federal court in Wyoming has ever let that issue go to the jury, number one, or number two, where those damages have been assessed and upheld in a reported decision. So I sit here and I'm just not aware of that. I could not find any reported cases where that was discussed. So I just wanted to, let you all be aware of that. Now, the idea that you're not liable as a matter of law really doesn't answer the question of whether or not you're required to pay. And so that's where I did some research today and said, okay, is this council really required to pay if those damages were assessed? And the only case I really found that was on point, that's still good law, is Campen versus Stone. And the Wyoming Supreme Court has adopted what's known as the restatement of torts and the restatement of agency. And there's 4 circumstances where a municipality would be liable for punitive damages. And one of those circumstances is the agent was employed in a managerial capacity and was acting in the scope of employment. So, or the principal, I'll give you the 4th one, the principal ratified or approved the act. So if the council approved the act, that would be another circumstance. And so it is on the basis of that that I say to you that really this amendment simply codifies what the current law is in Wyoming on this topic. But it allows the contract employees to have something in writing that counters this letter that says there is no coverage under a coverage that is available to the city.
Thank you.
So hopefully that explains it. It's a complicated, very specialized area of law. But that is really the current status of the law and the need for an amendment. It's really to make the recipient have a comfort level as to what exists.
Questions for Ms. Studer? Councilman Johnson.
I was one that wanted this pulled off the consent agenda because I had some concerns and confusion on what this meant, and I thank Ms. Studer for clarifying that for me. One question I do have is, says damages incurred while performing their duties within the scope of their employment. Who decides that they were acting in the scope of their employment? Would that be the courts, or would that be the council, or how would that?
Initially, the determination would be made by council. I would assume with the advice of the city attorney if that city attorney is not involved. But the initial decision would be made by council. If there was a disagreement, that could be a subject of a lawsuit, whether or not the person is acting within the course and scope. Typically, this comes up at the front end. If there is a lawsuit, you review the claims, and council, or even WARM, if that's appropriate in the circumstances, would say, wait a second, that conduct is so egregious, it's criminal. We're not going to defend them because it's so clearly outside the course and scope. It's a criminal act. One of the easy examples is if a city employee were to sexually assault another person. That is an area where that's criminal conduct. That is not sanctioned. That's not within the course and scope of any job within the city. And therefore, there would be no coverage or defense offered to that employee. And so that determination is made on the front end, and that would occur in these circumstances also with a contract employee. Council would make that determination at the front end when the case was first filed. Sometimes it's a gray area. You don't know what the truth is, and so you may say, okay, we're going to defend you, but we're not going to pay the judgment. But it's really we're going to see how it plays out with the court, with the jury, because it really is difficult. The judge is a gatekeeper in a sense that they get to listen to the evidence and they decide, is this an appropriate case to even go to the jury? And so that's a reason why sometimes you wait to determine if they're even going to be assessed before you make a determination as to whether or not you're going to pay it. And an example I had given, because it's an example that I deal with on a not daily basis, I have dealt with in the past, is when I defend public officials and they have been sued. They basically, if they go to a bank, try to get a loan and want to take out a mortgage or something, a lending institution looks at that and says, we will not provide a mortgage to you because you have this lawsuit. And typically what I will do is that, well, even though they're named, there is coverage, or the public entity will pay any judgment to satisfy them that really the lending institution isn't at risk, that there's going to be this huge judgment that goes in front of any security they may hold. So, I mean, there is practical reasons for doing this. Again, it's just to give assurances to the contract employees that they're going to be treated the same as every other city employee.
Thank you.
Questions? Ms. Studer.
I do have a question. You were talking about federal law and state law. Could you restate those two things again, please?
Sure. In order to sue a municipality or a public employee, it has to be under law.
Mm-hmm.
And under state law, it has to come under the Wyoming Governmental Claims Act, Section 1-39-101, if you want to look it up. And basically, under common law, there was complete immunity. You could not sue. But we've now, or the legislature has decided there's certain exceptions. But even if you fall within an exception, the legislature has determined we are not going to allow it. There's a specific statute within that act that says punitive damages cannot be assessed against a governmental entity or a public employee. So then that leaves, is there federal law out there that may impose such sanctions? And that's where the U.S. Supreme Court has said you cannot impose punitive damages against the municipality because of common law. They've always been immune. And Congress has not changed that or tried to change that. So then that leaves these public officials who can create public policy. And they are the city attorney, the judges, a city manager or city administrator, because they are policy makers. So they stand in the shoes or act for the municipality. And that's why I said why plaintiffs in a lawsuit name a public official as an individual is just so they can try to get punitive damages. Not that they will, not that a judge will, allow it, but they always, or they, not always, but they try to ask for it many times.
Mr. Vice Mayor.
I know that in criminal law, if you're accused of a crime, you go through an arraignment process, the likelihood and probable cause are established. Is there any kind of process like that to discuss the merits if you file a lawsuit in federal court, for instance?
A lot of times, a defense attorney will file a motion for summary judgment once the discovery is completed and say to the court, here are the facts. Giving them every benefit of the doubt, it doesn't rise to that standard. And the claim, like I said, it's really not a separate claim, but the court will say, I'm not going to instruct on punitive damages. So it's no longer in the case. Sometimes the judge will simply say, I'll just wait. I'll hear the evidence. All of the times, all of my 1983 civil rights cases, the judge has just never instructed it. It's especially our federal court. They're very reluctant to instruct a jury on this, but there's no probable cause hearing per se.
So essentially, if you have enough money, you can file a lawsuit and it's going to start the process.
Yes.
Extortion.
So if I'm understanding, if someone just wanted to make someone else's life miserable, they could file a civil lawsuit with no grounds. The person could be completely innocent, but because that lawsuit is pending and because they have no protection from punitive damages, they could be prevented from a variety of financial transactions, such as buying a house.
Potentially, and the reason I say that is because then all you can do is say, well, my lawyer says I'm not going to have to pay. Banks want something in writing, and even if it's just the lawyer's opinion, that's usually not sufficient. They want something from the person that will pay, and so that is why.
And going back to Councilman Johnson's question, in your experience, and maybe this doesn't happen often enough to really have a lot of experience, but is the question, because as Councilman Mundell has pointed out to us, the standard for punitive damages is very high. Words like outrageous and egregious tend to be in the statutes. Has that been a difficult distinction to make, or is it generally pretty obvious when someone has carried out an action that's outside of the scope of their duties, or acted outside of the scope of their duties?
For the most part, it's usually easy to say because that's so outrageous. You say that there's no way that's within their employment. If you take you're driving a city vehicle and you go buy a 6-pack at a liquor store and have an accident. I don't think that's going to be in the course and scope. I mean, so it should be pretty simple. What's more difficult, and when there's allegations that you simply acted outside the scope and you're not given sufficient detail or you don't know the facts. And so that's when a lot of times you do have to defend and you have to go through the process to a certain part and have to all the headache before the facts are determined, and you prevail in essence and prove that they're not founded, that there's no basis for those facts.
Thank you. Other questions for Ms. Studer? Thank you. Mr. Ball has again requested to speak with counsel on this item. Thank you.
Thank you again, Your Honor, counsel. This is a consent agenda item, and what I just heard Lawyer Studer say is that you guys are willing to give up sovereign immunity to protect a bad hire. That was what I just heard her say. And let me elaborate on what I understand punitive damages to be. They're intended to reform or deter the defendant and others from engaging in similar conduct, not intended as compensation for injury or losses. It's payment in excess of an individual's probable loss. Well, I don't know. This must have been written by a lawyer. Where does this start and stop is the question. I believe Mayor Powell pointed out that this is being predicated into this voting process because there's a lawsuit. Does it go on past our city manager's issue with the need for the city to protect him from something that he has brought upon himself, this council and this city? And if so, where does it start and stop? Where do punitive damages go? If a police officer tases an 80-year-old man, could there be punitive damages there? Yeah, probably. Violation of the implied covenant of good faith and fair dealing that is in every contract, thus every contract between the city and other entities. Individuals provide exposure for the taxpayers. In some way determined city's employees violated this covenant by doing anything to prevent the other party from receiving his or her benefits as a bargain